Yes, welcome to the No State Project here on. It's just my Ustream, but it's the Wednesday edition of the No State Project, commercial free. We're here most Wednesdays live, of course, from the fortified compound in Mesa, Arizona, from 3 to 4, about 3 to 4 every Wednesday Pacific time. You want to join me here on the big show, it is 218-632-9399, 218-632-9399. It is, of course, episode 25 of our 25 episodes in of the No State Project, commercial free. I'll try to update the site here so that we know that it is July 12th, not July 5th, so we'll save that. And I want to thank everyone for the continued support of the show. I do appreciate that. I don't ask for a lot. We just need some, and so we have a number of people who have generously contributed on a regular basis. I do appreciate that. If you would like to help support the show, just go to markstevens.net or my sales channel, my sales site or account, whatever it's called, my sales page, and you could do that. Let's get all the things. We got a lot of stuff to get to today. A lot of stuff. One of those weeks. We've got Jackalope. So let me get Jackalope out of the way. Remember, Jackalope Freedom Festival is going to be July 31st to August 6th in Bacchus Meadow in northeastern Arizona, about an hour and a half, 2 hours northeast of Phoenix. It's absolutely beautiful. A meeting of fellow anarchists, not people who want to do like the Free State Project and just use that as a vehicle to become politicians so they could just be politicians. People will understand that you're not going to bring about change, any meaningful change in the direction of more personal freedom by becoming a bureaucrat. No, this is about nonviolent non-cooperation and building a system, an economic system outside of their system. So check it out, Bacchus Meadow. We should be there at least one of those days. I'll probably be there on the Saturday. Maybe not. Calvin should be there, so maybe we'll check out a Thursday or a Friday. But looking forward to that. Remember, it's July 31st through August 6th, so check that out. Got an update yesterday, some bad news. I did a video about this, regarding Ed's situation. There was a prosecutor named Gene Barrett. So if you go back into the videos, a few weeks ago, I did a video about prosecutors flipping the burden of proof. Prosecutors can't stand being held to their burden of proof. They absolutely hate it. They love making complaints. They love accusing us of all sorts of nefarious and horrible things. Well, horrible things really in their eyes, because, of course, not paying their salary, not taking care of their pension is probably the most heinous crime that they can consider. It's worse than murder. Not paying taxes is you're the lowest of the low in their eyes. So they really don't like to be challenged because really they're just a group of men and women who are forcing us to pay them. They're forcing perfect strangers to give the money, and just like and we'll talk about this later. Bill Montgomery, Maricopa County attorney. He's on the record. The evidence proving that the laws apply to me because I'm physically in Arizona is because he's put other people in prison. That's a hell of a strong position there. So we actually have some discussion, an update regarding one of his employees. But before we get to that, let's give an update on what happened to Ed. Ed, in that video, we talked about the prosecution flipping the burden of proof. They are notorious for this. Will you tell me why the laws don't apply? Okay, you don't have any evidence. Your claim is pure speculation. You're just doing it based on what someone else told you. It has no merit whatsoever. Vox et praeterea nihil. Voice and nothing more. So you can go to that video, you can see the crap that he had to deal with. Although Gene Barrett was not going to be the prosecutor yesterday. So we went into court yesterday, and this has to do with traffic. And I think one of the worst things that they do is when they do convict you, and then they have to put you immediately in jail. He's not accused, it's traffic. He's not accused of anything violent. Nothing like that. It's purely non-compliance. He didn't comply with some bureaucrats in Ohio. So we tried to get the judge removed because he had knowingly issued a false warrant against Ed a number of years ago. Same judge. And it came out in court that the warrant was based on false pretenses. So you would think that that would be sufficient. Another judge admitted that it was a false, an invalid warrant. You'd think that that would be sufficient grounds to have him recused. Nope. Not only did he refuse to recuse himself, but even when we went up on a petition for writ of mandate, they refused. They didn't see any grounds. So what if he issued a false warrant against you? So he went into court yesterday. I had spoken with him on Monday, doing our best to get him prepped. But sometimes when we go in to deal with these people, we are dealing with crooks. And the evidence being that they force us to pay them. Forcing people to pay you makes you a crook. Even if it's for my roads or, my Medicaid, or whatever it happens to be. Theft is theft is theft. It's wrong. We don't accept a double standard here. It's okay for people like Gene Barrett to do it. It's okay for Donald Trump to do it. It's okay for Barack Obama or Joe Arpaio. It's okay. They're different. Bull. Not any damn different than me. Well, they're different in that they have no moral compass. They're different that they're criminals. They have to force people to pay them. And for those attorneys out there who want to tear me down, I don't force anybody to pay me. I have to do it based on merit. Unlike you lawyers, you ain't got to do it on merit. You got a monopoly. I have to have evidence. I have to have a persuasive argument. I have to back up what I say. And that's why people continue to support me. Remember, no monopoly. So when you go home to beat your wife or sleep around on your wife, steal from your partners, just remember that. You don't have any moral high ground when it comes to what I do. Zero. Nobody's forced to do business with me. Everybody I do business with is voluntary. Oh, it's just got to eat you up. We'll call the bar on you. Futuri. How about fungal? Okay. So unfortunately, back to what happened with Ed. And if you do want to join the show today, it's 218-632-9399. The passcode is 2020. You can also contact me on Skype. It is Frank Rizzo 3. Don't call me first. So we are doing a live broadcast over here. But send me an Insta message and say, hey, I'd like to join you on the big show. So unfortunately, I don't have many details. I can pretty much guarantee or guess, I have an educated guess based on experience, what typically happens and what Ed had told me had led up to this particular point. He was convicted, traffic, not accused of any violence or hurting anybody, purely non-compliance. And this is what I was getting to before. It really sucks when they throw you in jail right after one of these things, especially when it's only for like 15, 20, 30, or 90 days. Because you're not going to be able to prevail on appeal before you get out. So their prison system is just racking up the money. They're making money off of you. And even if you do a habeas corpus, the reason why I even talked to him about it, there's no point in doing a habeas corpus when you're in for 15 days. He was given 15 days, and then there was community service and a fine. Where you can appeal all that other stuff, but the 15 days, you're going to do it. And even if it comes out that the judge maliciously found you guilty, did so against the weight of the evidence, there's nothing you could do. The judge, you cannot hold the judge personally responsible. Yes, you certainly can and should file a claim against the county or the city's insurance that covers the judge. And the judges are covered. The judges are covered. Just get a copy of the policy, go to risk management, read it. The judges are covered. So if they have absolute civil immunity, it's what we like to call insurance fraud. If you are not an insurable risk because you have absolute immunity, then they shouldn't be covered. But you'll notice that they are. So I imagine the way it went and being asked here about talking about appealable errors. And it's always good to talk about them. Like I mentioned to Ed, when you go in there, you are doing it with the mindset that you're going to be getting appealable errors from the judge. Because the judge can't help himself. You're guilty before you even walk in the door. You're guilty. And that's why I've mentioned before, everyone who's ever been through one of these traffic court proceedings or a tax proceeding, you know the drill. You are guilty, end of discussion. So every single thing that happens, every objection, every single question to a witness has to conform to that decision. You've already made up your mind you're guilty. Traffic court, you guys are the lowest of the low when it comes to judges. You are absolute filth, just the scum of the earth. You are absolutely already have us guilty before we walked in the door. We know it. You know it. Some of you don't even want to put on a show. I can't remember the name of the scumbag who convicted Ed yesterday. But they have you look, there's no pretense here. They don't care. The prosecutor doesn't have the evidence. He doesn't have to prove it. You can say, but he's right, he doesn't have to. Well, because they have a prison system, not because it's fair. If it's fair, you don't make claims that you can't back up. And if it was legitimate to make arguments without any evidence whatsoever, I'm talking practical application of the law, practical issues of law, and fact. If it was fair to make such arguments without any evidence whatsoever, why don't they let us do it? Double effing standard. It's a double standard. It's not fair. It doesn't matter if the judges say it's fair. Look at the side that they're on. They're going to say that their guy made a mistake, something that they've done their entire career. So Gene Barrett was not able to produce a single supporting fact to support his conclusion that the Constitution, a written instrument, applies to Ed just because he's physically in Ohio. All they could do is repeat the argument. All they could do then is say somebody else said it was true. Again, proof by assertion. Just because you say it's true doesn't mean it is true. I can call Gene Barrett a pedophile. Let's say he molests children. Okay, he's guilty of violating the code, molesting children. I don't have a shred of evidence to support that, but I shouldn't need it because Gene Barrett doesn't need any evidence against Ed. So appealable errors that Ed is looking at here that we want to look at. Prosecutorial misconduct and Brady violations. Those are huge appealable errors. We know that Judge Kaczynski, and I'll get this in the video, Ninth Circuit Court of Appeals judge, that Brady violations are at an epidemic level, and only judges can bring bring an end to it. Only judges can stop it. Well, and that's the problem. What do you do when you've got practically every single judge who will not hold the prosecution to the burden of proof? But Marc, he doesn't have to prove that. You're making my point for me. It's an element of the charge. Here, let's go through this again. The applicability of the code and the Constitution is an element of the charge, and yes, I know, they don't always admit that. I get it. But we're talking about a mala prohibita. It is only wrong by virtue of the law. So how can the law itself not be an element of the crime? How could they say it's applicable? They don't say the applicability is irrelevant. It doesn't matter if it's applicable or not. They're willing to shoot you because they believe it does apply. They will scream at the top of their lungs, the code applies. They will do, right? They will insist it does. They're not saying it doesn't, and they're not saying it's irrelevant. They're saying it's not necessary for the prosecution to actually prove it. Well, it's not just jurisdiction, and we've already gone through jurisdiction does include facts. It is not a pure issue of law because your physical location goes to territorial and personal jurisdiction. So it's not a pure issue of law, no matter how many times these criminals say it. Well, if I just say it enough, I mean, this stupid anarchist will leave us alone. No. And the show keeps getting bigger, and we keep reaching more and more people every week. We're almost at the magic 9,000. We're going to be over 9,000 subs soon. We'll continue teaching people that you're dead wrong and that you guys are a bunch of crooks. Jurisdiction is not a pure issue of law. Why? Because territorial and personam jurisdiction require physical location. Not only that, but subject matter jurisdiction, which cannot be waived, is based on facts. If taken as true, would show that there was a valid cause of action before the court that the court has jurisdiction over, such as traffic. So it has to be a case of controversy, not just an accusation. Well, we're accusing him of traffic, so the court has jurisdiction. No! You have jurisdiction over cases and controversies, not all accusations that are traffic or taxes. You have to have a case of controversy. They always miss that particular part. But we don't have a case of controversy. You have the violation of a legal right and the damage that we... No, you don't. You have an accusation. You have no evidence whatsoever because you keep saying he doesn't have to prove that the code applies, and the code is what's creating the legal obligation you say was violated. This is basic common sense. So that's, again, territorial, personal, and subject matter jurisdiction. All three of them are issues of fact. They're issues of law and fact. They require some evidence to make a determination. It's just like someone's guilty of murder. Okay, where's the evidence? But murder is taking someone's life with malice aforethought. Yeah, but where's your proof? But that's what the law says. Where is your damn proof? Oh, we don't have to prove that. No, we don't have to prove that. You see, when it comes to certain aspects of crimes like murder, robbery, rape, real things like that, they're never going to make these claims. They don't have to prove that. Oh, but when it comes to the Achilles heel, when it comes to the very foundation of the prosecutor's case, the very foundation, which just happens to be what we're going to talk about next regarding, I actually have a decision from a judge. And the reason why prosecutors, it's unusual to have somebody like Gene Barrett actually give you something in writing as a response, because you got to open up a big can of stupid to try to explain away why you won't have any evidence. Well, it's not up to us. We don't have to prove it. They have to show that it's wrong. So, again, the same thing. They don't have a shred of evidence. They know they don't have any evidence. They don't think they need any evidence. Yet, if we want to disprove their speculation, we have to have evidence. So, yeah, jurisdiction is a pure issue of law, but if you want to disprove it, you have to have evidence? Really? The contradictions are just too fast and furious. So anyway, we'll get to Bill Montgomery's people in just when I finish talking about some of these appealable errors, which will go into what we'll talk about with the appeal document that I got. So Brady material, for those who are not familiar with it, we'll keep repeating this because it's extremely important. Brady material is any information, evidence that the prosecution should have that shows that you're innocent or can be used to impeach the evidence or the witnesses that the prosecution is planning to bring you. Now, one of the most ignored rules, because it happened again to Ed just yesterday, if the police officer said you violated the law, they have to have personal first-hand knowledge on it to get on the witness stand. And even if they don't say that on the witness stand, he already said it, and that's what led to the stop, the arrest, and the prosecution. It was said at the stop and is a valid subject for cross-examination, which we'll cover in detail with the next segment. Brady material is, as soon as they file the complaint against you, that turns it on. The prosecution is required to give you that. Now, no matter who is calling a witness, for whatever reason that they're calling them, you have an obligation before you put them on the stand, before you put them on the witness list, before you rely on them, before you even file. It should be before you file the damn complaint. You should interview the witness to make sure that they know what they're talking about. Rule 602 states that, we'll use the Ohio one in the video, that no one may testify as a witness unless evidence is introduced to show that they have personal knowledge of the matter. And it does say that the personal knowledge can come out through their testimony. Again, discovery, it's not supposed to be a surprise. You're supposed to know what they're testifying to. Because the police officer started this with legal conclusions. Legal conclusions, not judicial conclusions, you anal retentive jackass trolls. He made a legal conclusion. Let me just take a moment and explain this. When you apply the law and say to somebody that they violated the law, you are making a legal conclusion. So I have been accused in the unauthorized practice of law because I'm giving legal opinions, allegedly, to people, and I don't have the permission to do so. Okay? Giving legal advice, giving legal opinions is considered a crime. But cops have a legal exception to that. They're allowed to do that because it's part of their job. When the police officer says that he has probable cause to arrest you for violating the law, those are legal conclusions. If you dispute that, you're either completely ignorant on political and legal proceeding, or you're an idiot because you're just trolling. You've got a vested interest in making sure that these scumbag cops, these criminal prosecutors, and these pieces of garbage judges look good. You try to, it's just like all this crap that's going on right now with the, with the White House. Everyone goes into damage control to try to justify everything that's coming out. All the stupid excuses that you will hear. It's the same thing here when they say, well, the cop's not making legal conclusions. No, the cop is. A determination of probable cause is a legal conclusion. Any disagreeing with that, you just don't know what you're talking about. So because the police officer is making these legal conclusions, he's making these legal opinions that you violated the law, he has to have personal firsthand knowledge if he's going to testify to that. And of course they do. They do. You know what a probable cause hearing is? That's when if there's a felony, for example, that they just filed a criminal complaint against you and you haven't been indicted. And they have to show probable cause. Well, the individual cops who made the determinations that there was probable cause you broke the law are going to be put on the stand that you can then question. They're going to testify that there was probable cause. That's a legal determination. Yes, it's based on facts, fact and law. It's not a pure issue of law. Otherwise, you would have a probable cause hearing. You would have a grand jury investigation. Grand jury determines probable cause based on the evidence that the law was violated. So, issue of law and fact. Just like jurisdiction. So, the Brady violation, prosecutorial misconduct. The judge allows the prosecutor to testify, allows the prosecutor to argue without evidence. Big appealable error. Judges don't give a damn. And again, I didn't say that Brady violations are at epidemic level in the United States. A federal appellate judge did. So you can disregard, the trolls can disregard what I say, but go ahead. Take issue with Judge Kaczynski. I don't care. I live it. I know what's going on. I get the reports of these scumbag judges. I hear sometimes firsthand and watch these judges do this. He doesn't have to prove that. It's the whole case. In a code violation, the applicability of the code, jurisdiction, is the entire case. It's 95% of the case. He doesn't have to prove it. Yeah, because you're a bunch of damn crooks. Real quick before I get a call, I want to make sure I don't run out of time here today. Another appealable error, of course, is your denial of effective cross-examination. And I'm going to cover this in much more detail in after I take a call. But that's huge. Huge. And you won't, and the stupid things that you'll hear from these judges and prosecutors to try to justify not allowing me or you to ask questions to a police officer based on what he said and did at the stop. It's more evidence of these crooks. It's also going to be, I think I'm going to include it as my second installment of these lower level bureaucrats you don't tend to hear about, like I did last week, and I appreciate the views on people linking that. So we had, it was Greg Ives, that his crimes led to destruction of a peaceful business, and of course I couldn't get a picture of him in the video, but but here I'm going to show you in the video for this, when it's not live, but when we get the video posted, and I'll have an article. I have a picture of the judge who gave us the latest round of nonsense, trying to justify denying cross-examination. It's just they'll say anything, and this is further proof. I'll have it up here. You can read it for yourself, and you can download a copy of the actual appellate order. But let's see what our friend in Detroit's got. Hey, Tom, welcome back to the show.
Hey, Mark. How you doing this afternoon?
I'm doing well. How you doing?
Doing well. I have a couple questions I'd like to address.
What do you got?
All right. Well, the first thing that you just said was very interesting. You said jurisdiction is 95% of the case. And then my question would be, then why is it so easily bypassed on an appeal? I mean, like you said, you have to shock the conscience to get the appellate court to actually dismiss or what they call it, repeal or whatever your case. And yet that is like spotting a unicorn.
A lot of times on appeal, Tom, they just ignore the issue. I can show you where I work with an attorney that was sanctioned for arguments that weren't even raised. It was a literal copy and paste job from another case, and all they did was put the attorney's name and the case number on it. They sanctioned her for an argument somebody else made, totally different case, and there was no way to get it over, and it was done, and it was a $50,000 fine, by the way. So a lot of times they don't even address the issue. Or with Marc in Wisconsin, I wrote the appellate paperwork. I know what was in that. They didn't address not one issue we raised. So it's a huge part of the case, but they tend to ignore it.
Well, see, this is why when I try to help people, I make it really clear that of course we go in there. The idea is to build an appealable case, appealable errors. But since the winning an appeal is so rare, I try to focus more on damage control. And I know a lot of guys that are part of this thing really don't like that. And, yesterday, James Monroe was in a court case. And the night before the case, we discussed it. He was happy. He thought the original damage, the fees were $1,600, which they weren't. I listened to the recording, but let's consider that. And he was prepared to a degree, but not really. And he said, if I could get this down to $800, I'll be happy. He got offered $430 to walk away, and he went in there and gambled and got his ass handed to him, and now it's $1,700. So that's why I emphasize damage control. I mean, winning on appeal is like spotting a unicorn.
Well, it's not as rare as you think. We have had written appeals where we've won. I just posted one not too long ago. That was his. I don't know what was going on. If they offered him $430 and he was willing to walk away with $800, I don't know what motivated him to continue, battling these people and defending against these lunatics.
Stubborn and greed, I think. I really like the guy, and I hate throwing him under the bus, but I'm pretty straightforward, as you know by now. But it really disappointed me. We have another guy on there, Sanjay, right now, that is. Yesterday or the day before, I think it was yesterday also, he walked out of court, and now he has 2 more weeks to prepare, and he knows, in my opinion, this guy, with his own his words, he's never going to be ready for this. People have to realize what they're getting themselves into, and if you can achieve damage control, cut the thing in half or whatever, man, I hate to say take it, but if you can't really go through this, and he has no money, he's straight up said, I can't afford anything. You can't play this game. It's like going to the casino with no money. You're stupid. Sorry.
Well, it's short-sighted. I wouldn't necessarily say it was stupid. It depends on the situation. But yeah, if he had not, if he couldn't even, even the 430, he would have to go through a financial thing and to be able to pay that in payments. They'd have to let him do that, and he'd have to disclose all that. And most of us would rather not do that. I don't, maybe he may. Look, I know from my own experience. Sometimes you're in the heat of the moment, and you just can't let them get away. You have to fight them. You have to defend against these animals. You have to. And if it means I'm going to do time, some people are willing to do that. If he's willing to go through the appeal process, it's going to be tough with no money. But I don't know what was it. Traffic?
Well, there's two. You're confusing the two. James was one. Both of them are traffic. Okay, James was the one that got the offer for the 430, and he decided to go in there and try to battle with the judge, and then said, "I'll take the offer." And most people don't understand that once you've said no to that offer, it's off the table. And he got his ass handed to him. Now Sanjay, he was in there. He's the other guy. He's the one that has no funds, and he now got it postponed for 2 weeks, and he thinks he's going to do better in 2 weeks when he just doesn't have the fortitude to do this, and no funds. With somebody that has no funds and playing this game, it's just, in my opinion, very foolish. I mean, I'm with you, brother. Fight these guys tooth and nail if you can. If you can afford it, you have to weigh all this stuff out, or you're just gonna hurt yourself so much more.
Yeah, and that's true. Not every battle should be taken on, and I don't know the motivation. It could be a matter of principle that, look, I'm going to prepare as best as I can, and I'm going to fight. And because it's a matter of principle, so that at least I fought these bastards. That they didn't put me in jail for a few days or seize a bank account because I just laid down and did nothing. I did something to expose these people for what they are. So, but I don't know his motivation there. And I tell people, I mean, I had to speak. I did a consult with someone the other day, and I told them straight out, if they indict you, you are in deep trouble. Deep trouble. And there are things that they can do to make it 100 times worse. They can just force an attorney on you and you're done. I can't defend myself? No. Nope. If they really want to shut you down, they force an attorney on you, you're completely muzzled, you end the discussion, you're done. And good luck appealing that. Again, which, sucks, but if you
Reality.
but we have had success on appeal. It's not like it's this magical unicorn you're talking about. We do. And most people, unfortunately, usually just walk away and don't pay the fine, or they wind up paying it and not appealing it. So not everyone appeals, but it's unfortunate they have to say these stupid things. I won't do it now. I'll do it when you're off air. But I want to go into what happened here in Arizona regarding the stupid things that come out of their mouth. To justify ignoring certain things. This one is just one of the, I've heard things like this before, but we generally don't get it in writing. So now I can put this woman's face to her stupid ruling, which would be nice. And yes, I have permission to do that. But what was the second question?
Well, it was basically those two issues, and I do want to thank you also. I'm having an issue right now with my last employer. They basically robbed me of $1,100+ of my last paycheck with an arbitrary rule. They're arbitrary ideas, and I'm at the point right now. I've been being very nice, trying to play the Columbo thing, just asking them, the CEO questions to send me documents, and I just got his last one back now that I posted in the NSP. So the Socratic method definitely works in life. That's the one thing I got to thank you for, man. Once you learn this method, it works every day. And when somebody's trying to lie to you or pull the wool over your eyes, you can dissect that very quickly. So I thank you for that, brother.
Well, I appreciate that. And I would just put in there that the Socratic method is not difficult to learn the principle and learn the basic, keep the burden of proof on them where it belongs, ask clarifying questions. As long as you do the role playing, and Sanjay, if he does the role playing, he should be, pretty well prepared. He's got 2 more weeks to do that. I tell people all the time, the difficult part is just keeping focused and keeping calm when people are lying right to your face like that and don't give a damn. To watch these judges and prosecutors say these things that are affecting you. And they're false. They're lying through their teeth. Well, they just don't give a damn. They're sitting up there and this scumbag judge is just saying anything else because he's already made up his mind. Anything. There was a judge who literally did that. Anything else. You bring up the prosecution has no witness. They have no evidence. They admittedly don't have a case. Anything else. And that's the difficult part. It's not getting them to contradict themselves. It's not difficult to get them to say stupid things and these stupid justifications. It's being calm and focused while you're going through this with these animals. That's why the role playing is so important.
Yeah, and exactly. And it's not just the role playing, but the actual person's, intestinal fortitude, as I like to call it. You can either do this or you can't. I mean, it's like any other job. When you're in there and we're all scared. I don't care who you are. I mean, I'm sure you were pretty. If your ass was on the line and it was, you facing the possible cage, it scares us. And once you're in fear, it's very difficult to stay focused.
Yeah, that's why we do the role playing, and so that you can take away some of the apprehension because there shouldn't be anything that surprises you. You should know you should be able to. Because of the simplicity and the effectiveness of the Socratic method, you should be very well prepared to whatever they happen to say. Because at bottom, there's no way that the prosecution can make their case. They cannot do it. It's dealing with all these.
There isn't even a case.
Yeah, there couldn't possibly
even the word
be.
Case.
Yeah, there's no case.
The word case itself it has meanings to it, and it requires certain elements. And I agree. That's why one of the things that I try to do when I work with people is say, listen, the script is all fine and dandy, but you got to put that aside. You either understand this concept or you're going to get absolutely steamrolled.
Yeah, and
once you understand this, I'm sorry. Go ahead. Well, I was going to say, once you understand this concept, it doesn't matter what comes at you. Sit down and listen to what they just said and ask a question about it. You could do this all day until number 2 in the room comes out, the gun.
Yep.
You're aware of the 1, 2, 3 that Gary, came up with his little baby, which that's it, man. 1, we're here to plead guilty. If I've done something wrong and I need to make amends for damage or something that I've done to injure a person, I'm here to plead guilty. And 2, when 3 actually comes before 2, the prosecutor's failures. And you start bringing those out, and oh boy, that's when number 2, the gun in the room, starts appearing pretty damn fast.
Well, that's why I usually do it as if the motion to dismiss is ignored or I'm run over on that and they're forcing me into a plea, I intend on pleading guilty. Has the prosecution met their prima facie burden on jurisdiction? Yes or no? And we'll end it right now, buddy. Right now. And
they'll always say, yeah, the prima facie burden is the ticket. That's all we need. That's prima facie right there.
Yeah, but if they say that, so you're saying that the prima facie evidence is listed on the complaint.
Yeah, the complaint itself. You were in such and such a city and blah, blah, blah. That's prima facie.
The complaint does not.
Mean?
Well, no, prima facie means that the evidence, if accepted, is true with no investigation, no cross-examination. If the evidence reported is true, then there's cause to...
Prima facie means on its face.
At first glance.
Yep, on its face at first glance. Well, there's the ticket. I'm not arguing with you. I'm just telling you, damn well that's what the judge...
I know, and that's why it's a good point, and I want to explain it for people who are listening. they may try that, and they do try that. We've addressed this many times, that you're asking, so you're saying that the prima facie evidence proving that the Constitution and Code apply to me is on the ticket? And well, yeah. That's why we say, all right, what? And every time I've done it, when I pulled that crap, and people have reported the same thing to me. The judge will reverse himself and say that the ticket is not evidence of anything.
Huh.
Well, we even have in government indicted, and we've got on the wiki, we've put it on the page, U.S. versus Bailey. Even the U.S. Attorney's Office, if you look at their website, when they post an indictment, say the indictment is not evidence. U.S. versus Bailey, the Court of Appeals affirmed again, the complaint is not evidence. The complaint contains or lists evidence, but it is not evidence. So it's real easy when they try to say that the ticket itself is prima facie evidence. No, the ticket is an allegation that's supposed to have evidence listed on it. It is, so I'm glad you raised that, because it is a tactic that they like to use. I will say it's not a very common tactic. They try to say that the evidence is in the complaint, not that the ticket is the evidence.
Right. Well, one other thing too. Last night when I listened to the recording, when the judge was pretty much reading, the sentence or something along that line, he brought up his he wanted to have his allocution, and the judge actually gave him damn near 10 minutes. And during that allocution, he brought up the motion to dismiss again, and the judge actually listened and asked the prosecutor to, argue the motion. And of course, the prosecutor pretty much said it was frivolous, and she said denied. But I was pretty surprised how much time he got during that allocution, and the fact that the judge actually asked the prosecutor about that motion at that point. That was pretty interesting.
Sometimes they do. I mean, they had someone on the show a few weeks ago, I forget his name. The judge went and said it was a very well-written motion. He said it covered a lot. It covered a lot of ground. It looked great, but denied. Oh, no explanation. It just denied. So we're not.
Yeah, but I mean, my point was that he did this during the allocution, which that I never. I mean, I don't know. I'm sure many people don't know what the allocution is, but that's your last card you can play to the judge, basically asking for mercy or whatever you want to do. And I was shocked how much time, because she kept, you know how it is with judges, they cut you off, they don't give you any time. I was shocked how much time she gave him to rant on and then challenge the motion, which they really never did or addressed, and then it was somewhat addressed. I mean, it really kind of surprised me that how that allocution can be used. At least that's a last ditch effort.
That's true. So, hey, I appreciate the.
That now that you just mentioned that, impeaching the police officer, that was the other thing James did during. If you listen to the recording, it's posted in the NSP. He met with the prosecutor. I suggested he do that and get this thing. He got it down to 4:30, but then he wasn't satisfied, and he starts bringing up that question, the question you'd want to ask the cop on the stand to impeach him. He brought up to the prosecutor, and I found that was tipping his hand. Why would you want to ask the prosecutor about impeaching a police officer?
Because
I thought that was kind of...
look, this is a common thing, and I okay, it doesn't. We don't need the element of surprise. The prosecution does not have the evidence. The prosecution does not have a qualified witness. We ask him straight. We ask them who their witness is with personal firsthand knowledge to prove their claim that just because you're physically in Ohio or wherever, or Detroit, that their laws apply to you. We say that months in advance before you even... So by the time you get to even pretrial, they already know what you're doing. So the element of surprise is lost almost immediately. You don't need it.
Right. Okay, understood. I thought it might have been a bad idea to tip that hand. It didn't help him because he ended up getting screwed at the end. But anyway, all right, thanks, Mark.
Oh, I appreciate it. Thanks, Tom. Appreciate the call. We gotta keep in mind, and we're talking about damage control, and I talk a lot about getting leverage with the prosecutor, and you get leverage from the prosecutor by bringing out that he doesn't have a damn leg to stand on. You can even say, are you really going to go and ask this judge to allow you to argue without evidence? Or are you so confident in your relationship with this judge that you don't have to, that you know in advance that he'll let you do that? You know, not having a qualified witness, not having the evidence, and making him and letting him know, I am going to be your worst nightmare in court. I am going to dress professionally, but I am going to object to every damn thing that you say because you're full of crap. Every question practically you asked your witness, I'm going to object. Every witness that you ask your witness, I'm going to be there to object. During your opening statement, every time you mention something that you don't have evidence for, I'm going to object. In your closing argument, when I know you're lying through your teeth and you don't have the evidence, I'm going to object. So that we get leverage. It's just not worth it because you're going to keep calling them out on their lack of evidence, their lack of proof. You know, let them tell a jury that was forced to be in there, they don't have to prove it. Let them say that in front of a jury. Let's see if their arrogance will transfer to an opening statement. And they want me, the county attorney, they want me to prove the foundational claim of my entire case. The gall of these people. This filthy anarchist over here. I have to support my claim? He's making it sound like I have a burden of proof here as a prosecutor. Put him in jail where he belongs. That'll prove the laws apply. Put him in jail with everybody else we've put in jail. Take your burden of proof nonsense and shove it. I'm a prosecutor. But I have not heard of anybody having a prosecutor right in front of the jury or the judge telling the jury they don't have to prove that. I, the judge, will do it for them. That's exactly what basically happened behind the scenes with James in Alaska. I'm the judge. I will tell them what the law is. I will tell them what applies. That's the prosecution's burden, not yours. You giggling, laughing little school. Anyway, I don't know. Maybe I'll do this. I should still do a separate video. We'll see how this goes. But talk about appealable issues. Wow. And I certainly wouldn't recommend that somebody appeal if there was no chance. And so this has gone from the municipal court in Chandler, Arizona, to the Superior Court on appeal. And the judge, which we have a picture of, is Patricia Starr. Patricia Ann Starr. Did I got that right? Yes. And this was an uncontested appeal. Daniel James Maggi, we have a picture of too, is a prosecutor working for Bill Montgomery. Remember, Bill Montgomery is the guy who is the head of the department. He's the county attorney. The laws apply because we put other people in prison. Yeah. They're not saying that to juries for good reason, because there could be one person on that jury that would say, they BS me. They're like, whoa. What? I've been to high school. That smells like crap. Because it is. So there are a number of issues that are here that are laughable, but I'm going to focus just in the remaining time I have on the justification to deny cross-examination. So to give the issue was that the appellant contends that the trial court abused its discretion by not allowing her to cross-examine state's witnesses. The right of cross-examination is included in the right of confrontation is guaranteed by the Sixth Amendment. Although the right to cross-examination, is basic, it is not absolute, as the trial court has discretion to limit the scope. But that discretion is not very broad. It's only to things that are not relevant. And relevance is fairly easy to show if it has any tendency to prove a proposition. Any tendency. You have to have some connection there. That's why your physical location and a written instrument from 200 years ago, physical location does not have any tendency to prove something a written instrument applies to you. It's not how written instruments work. Okay, admission of evidence is within the sound discretion of the trial court, and the reviewing court will uphold the trial court's ruling unless there appears to be a clear abuse of discretion. They cross-examined each of the state's witnesses. The trial court sustained relevancy objections from the state and did not allow appellant to ask questions of the witnesses that call for legal conclusions. The trial court properly limited the scope of defense questioning. This court concludes that the trial court did not abuse its discretion by not allowing defense to cross-examine the state's witnesses about whether, quote, the Constitution and laws apply to defense, end quote. The trial court, this is what's important here. Anybody familiar with this show, anybody familiar with basic logic and how the legal system works should be laughing at this. Patricia Starr. I just got that. Patrick Starr. I think I know the thumbnail I'm going to use again. Patrick Starr or Pinhead. I just got that. Patrick Starr. Pat Starr. That's that. Patrick Starr, Pat Starr, sustained relevancy objections from the state and did not allow defense to ask questions of the witnesses that call for legal conclusions. This is mind-blowingly stupid. Okay? The police officers who were the witnesses, as I mentioned, made legal determinations. They made legal determinations that the laws applied, based on her physical location in Arizona. That is a legal conclusion. Our laws apply. We have jurisdiction to stop you. That is a legal conclusion. Remember, jurisdiction, pure issue of law? The cop is saying, I have jurisdiction to stop. That is a legal determination. That is a legal conclusion. So-and-so is physically in Arizona. The code applies. I have jurisdiction. That's a legal conclusion. You violated the laws. I'm going to arrest you. Those are legal conclusions. I'm going to file this into the channel of municipal court because they will have jurisdiction over you to answer for what I've accused you of. That is a legal conclusion. They testify to that. They have prior statements under oath. It's called a ticket. I hereby certify upon reasonable grounds that the individual named above committed the named acts, which are legal conclusions. They violated the code. These are prior statements. They testified she violated the law. They testified they had probable cause. There were no objections from the prosecution. Of course, why would Danny Boy? Why would he object to his own questions? Why would the judge not allow them to ask if the laws were violated? They can, see, that's the thing. They can make the legal determinations. And where this damn Patrick Starr, you crook you. The questions she asked did not require another legal conclusion. She asked for the evidence those legal conclusions that were allowed were based on. Do you just not understand the difference between the two questions? She doesn't say in here, and you'll see it in the video, she doesn't say anything in there that they weren't permitted to give legal conclusions. She was just saying she wasn't going to allow any questions about those legal conclusions. Because what it came down to is it's no problem for the cops to testify that she broke the law, that the laws applied. They can testify and say the Constitution laws do apply because she's physically in Arizona. But damn it, we are not going to allow you to effectively cross-examine those witnesses and ask for the facts those legal conclusions were based on. This is an appellate. This is an appeal. She doesn't even have the objection right, just like the trial court. How could she? And we put in there, you put in the appeal. The question that was objected to was not one that was being asked to elicit a legal conclusion. The cop had already freely given that without objection. The question that brought the objection on relevance was, where is the evidence? Where is your personal knowledge that that is true? You don't, this Pat Starr, you don't have a problem with the cops giving legal conclusions. Your problem is, you're a crook. You don't like anybody asking for the cop to verify it, to back it up with some damn proof. That's what you have a problem with. You have a problem with the truth actually coming out, that these cops, just like you said, were not qualified to give legal determinations. We had witnesses there. Dan, we know what you said. We know what was said. You said the witnesses were not qualified. Well, not this judge, but the trial judge said the witnesses, the cops, were not qualified to make legal determinations. How dare you then allow the finding of probable cause to stand? How can you determine probable cause when the witnesses who made the determination for it, at the stop, are not qualified to do so? They are so desperate to find you guilty in front of that jury and to force the jury to come. Thank goodness at least she was acquitted on one of the two charges. But they're that desperate. Don't tell me that those police officers are not making legal conclusions, because they are. And anyone who says that they're not, you're a liar and probably a crook too. Just like this Patricia Starr. They are making legal conclusions at the stop. It's on the tickets, on the complaint. They have testified to those legal conclusions. And yet, and the moment someone gets up there to defend themselves and question you on these stupid legal conclusions, you fall right for the tactic. We engineered it in advance to get you to do that, because we know that you are so damn corrupt, that you are so much still in the prosecutor mindset to do whatever is necessary to get a conviction. We know how dishonest you are, and we can walk you through the process. Every single time, I have said this since I did Adventures in Legal Land, every single time we ask a police officer on the stand, did you see me violate the law? Yep. The moment you ask them, do you have any evidence to prove that just because I'm, to support that, any evidence to prove that just because I'm physically in Arizona, your laws apply to me? Any evidence? Right on cue. Both those scumbag prosecutors were out of that chair. Objection. Calls for legal conclusion. Listen to the question, you idiot. See, that's something that has to be done right in front of the jury. Let the jury know. This guy he's not even listening to my objection. All he knows is that the question is damaging to his case, and he has to object. He didn't even listen to the whole question. I asked for the facts. So here, this is completely wrong. The question that was objected to, that is under scrutiny here, and that we're talking about, was, what evidence, if any, do you rely on to prove? What facts to prove that just because I'm physically in Arizona, your laws apply? It didn't require him to restate his legal conclusion. It only required him to answer whether he had, to tell us the specific facts that he relied on. But he didn't. All he relied on was what they told him at the police academy. The animals, the predators that are paying him. Go out and do this. And if you have a problem, you've been through the academy, you've got a gun, use it. Go through your force continuum. And if anyone asks you to prove, arrest them for contempt of cop. This is the kind of crap that's passing off as as a jurist, someone who knows the law, someone who knows basic principles of due process and right and wrong. You can't even read. But see, that's the thing, you can read. Pat Starr, you're just dishonest. You're just another dishonest crook. Hopefully, that we can, because it's such a clear-cut issue, the appellate court will look at the Court of Appeals will say, that's not the objection. You responded to a different objection. She didn't ask for a legal conclusion. She asked for the evidence the conclusion was based on, you idiot. See, if they really didn't have to have any evidence, the objection is still wrong. It's not relevance. Objection, we don't have to prove that. The witness is not required to have evidence. But it absolutely is relevant because it's prior statements, prior testimony. And it was totally unfair. This is what you can expect with these traffic courts. So I said, I mean, that'll lower the look at this crap. Well, actually, I'll have it in the video. Look at this crap. The court sustained relevancy objections from the state and did not allow defense to ask questions of the witnesses that call for legal conclusions. That is wrong. That is wrong. Did you determine on your own that the Constitution laws apply to me just because I was physically in Arizona? They're allowed to answer that. They're allowed to answer that there was probable cause. So if you're going to criticize, get it right. Actually lay out the objection or the question that was asked and show that it was a proper objection. Because when you ask for facts, any objection on relevance that it calls for a legal conclusion is just wrong. Just damn wrong. So I don't know if I'll use, we'll have this up in the video. I'll probably do a separate video. I don't know. But I'm out of time here. But this is, Pat Starr, Superior Court judge in Phoenix. Just another black-robed crook. So, but if you disagree with my analysis of Pat Starr's decision here to affirm the denial of cross-examination, if you think that they got it right and my analysis is wrong, I'm more than happy to hear that. We will be live this Saturday on the regular 3-hour commercial blocks on the Saturday show from 4 to 7 Eastern Standard Time. And we should be live again next Wednesday. So if you do have evidence to the contrary, or you can show where my analysis is incorrect, I'd love to hear it. But this has been episode 25 of the No Stay Project here live on Wednesdays, July 12th. Remember, Jackalope is in a few weeks. Go to markstevens.net. You can check that out. Just look up Jackalope. July 31st to August 6th in beautiful Bacchus Meadow. And I'd like to see that. I'll probably be there one day there this year. Again, my name's Marc Stevens. The website is markstevens.net. And, hey, till next time, salud.